Okay. Now, GE is a truly global company. We're talking about 305,000 employees, 170 countries. Annual revenue last year was 146 billion US dollars. Okay, but GE is a great proponent of mediation, and the Singapore Mediation Lecture, which was chaired by Ian 2 months ago. Okay, yeah, that was delivered by Brad Barrington from GE as well. So the sense within the mediation world today is that we have to listen to the users, the consumers. It's not about lawyers, not about mediators. Yes, we play an important role, but it's really about the users. What works for them? So we're privileged to have Mike here. Mike is a prolific writer. He's written a book called International Arbitration and Mediation, a practical guide. He's co-authored it with John Savage.
From Singapore?
From Singapore, yes. Some of you might know John. And he's a contributing editor with Kluwer Arbitration Blog. Okay? And he's a friend. We serve on the same board, the IMI, the International Mediation Institute, and Mike was actually a past chairman. Okay? Good. Now he's got a title which is very long. Why the Singapore innovations are important for global business. I prefer the second part. 2 settlements and a funeral. Please welcome Mike.
Well, thank you very much, Jordan. Thank you for inviting me here today. It's an honor, and it's actually somewhat intimidating to be in a room of such the global mediation community being represented today. And I just would like to start off by giving thanks and taking tribute quickly to the people who've organized this event. The Chief Justice Sundaras Menon for understanding how Singapore could become the center for international commercial mediation. The working group jointly led by George and Edwin Glasgow for transforming the Chief Justice's vision into reality through the establishment of CME and the Singapore International Mediation Centre, the board of CME for addressing the crucial element, and we'll get to this, why it's important to a business like mine, of transparency and competency and professionalism in mediation. And on that, I have to have a little bit of a self-congratulatory pat on the back to my own organization, not GE, but my other hat, it's IMI, the International Mediation Institute, and our executive director, Rita Vanikova, for the work that's been done together with CME here. And finally, for the Singapore Mediation Centre and for SIAC for collaborating, really, showing collaboration between arbitration and mediation, which is rare and extremely important. Mediation, as George said, is important for General Electric and how we manage conflict. As the head of dispute resolution for GE's largest industrial growth business, GE Oil and Gas, I credit mediation with helping me become more effective at my job and contributing not only to my success, but to my company's success. In order to illustrate to you today how the initiative being launched here in Singapore is relevant to companies like mine and people like me, I wanted to share some insight from some past cases, and that's why I've titled this 2 Settlements and a Funeral. So, 3 disputes went to mediation. All involved large sums of money. One was about a serious life-changing injury. 2 were about breaches of commercial contracts. The mediators were all agreed by the parties. 2 cases settled, 1 did not, and actually ended very badly. Here's the first case. This is Gavin Slessor. Gavin was born and raised in Aberdeen, in Scotland. In 2003, he was 28 years old. He played football, coached a youth team, and he worked at a local company called Vetco Gray, a manufacturer of subsea equipment for the oil and gas industry. On May 13 of that year, a lifting crane buckled and tons of steel fell violently on top of him. Gavin's life was spared, but he lost his right arm and leg. It was the worst industrial accident that Vetco Gray had ever experienced, and for Gavin, it seemed his promising life was over. He received some initial payments from Vetco and its insurers. This covered some of his most significant and immediate medical needs, but they did not agree on the total compensation that was due to him. As a result, Gavin filed suit. He was kept employed by Vetco, but he was put on gardening leave, and 4 years later, Vetco was acquired by my company, General Electric. Gavin took the initiative to write a letter to our CEO explaining, and I'll show you the letter here, this is from it. He attached some graphic photos of his injury. I've actually left out some of the more graphic images that he sent to my CEO. And he said in his letter, I've been an employee of Vetco Aberdeen for 15 years, and I had a major incident which you may or may not be aware of. The incident was devastating, for I lost my right arm and leg. I'm going through an extremely lengthy legal battle in which there seems no end. He asked GE to take a fresh look at his case. The CEO forwarded the letter to me, asking if I could do something about it. We'll get back to Gavin's case in just a few moments. I'm going to change and talk about something that's a little bit more common in our world. This is a different former employee of GE. His name's Anders Carlson. He's from Stockholm. A dozen years ago, he was the manager of a small GE company that was there. It had about 180 employees, and they built, and still build today, equipment for power relay stations. When Anders took over this business, he brought in new engineers who looked at the products in development, and they were not particularly impressed by one thing that they had in their pipeline. It was an invention by a Norwegian company, which the Stockholm business had licensed in exclusivity for distribution around the world. So instead of putting this product into production, they left the prototype sitting on a shelf in the factory. About 2 years after this licensing agreement was put into place, the Norwegians didn't see any revenue, so they filed suit in the Oslo courts demanding $600,000 in royalties. Anders got in touch with me, and I talked to him about his case. We looked at it, and we explained that it would be expensive to defend, and it did have some risk. Despite the assessment of Anders' engineers, GE had licensed the invention after all. So there were problems. Anders said he understood that there was risk, and in fact he'd offered the Norwegians $100,000 to settle the case. But they countered with $500,000 off of their $600,000, and they would not move further. What about mediation, I asked him. Anders didn't know anything about mediation, so we talked about it, and he got interested in the process, and he said, no, the problem here is cultural. He says, the Norwegians are, he says, well, you know how Norwegians are. I said, well, actually, I don't really know how Norwegians are. He says, well, they're not that bright, you know, and they're really stubborn, and it's going to be a real problem for us. I said, look, worth a try, you know, do you mind if I call them up and propose mediation? He said, that's fine. You can make the attempt, but just, you know, don't count your chickens. So I called the other side's lawyer, and she not only agreed to mediate, she actually offered to propose some good mediators that we could consider. And it seemed that things would be getting off the ground there. The third case is a Caribbean refinery. This is probably the most common type of dispute that I have to deal with in my job at an oil and gas business where we manufacture different types of heavy machinery for the industry. And it's the type of case that I expect you see a lot of here in Singapore, and we'll see more of because of this initiative with the Singapore International Mediation Centre taking off. It's a complex, you have complex international contracts, and there are cases where the reality is actually very clear to both sides. It's just that their realities don't match. As a result, you have lots of conflict. And in 2000, one of these cases was a refinery in the Caribbean, for which in 2005, my division was hired to refurbish all of the major turbo machinery equipment at this refinery. The project encountered, like many of them do, various unexpected difficulties, and these had very large impacts on costs. Claims and counterclaims totaled over $25 million, and there was the possibility of 2 arbitrations and their connected contracts being initiated in Houston and New York. These were openly threatened at this stage. But as in many of these cases, while you've got the arbitration positioning going on, you still have negotiations going forward, and although the claims and counterclaims totaled $25 million, the real distance was under $3 million. So we were close to, we thought, settling. Still, our general manager was upset about the hole this dispute was creating in his balance sheet. And he called for a briefing on the strength of our claim in arbitration. We explained that we had a good case. We thought that we would recover most of what we spent. Then he asked how long it would take. I answered, well, it's a large, complex contract. Lots of things happen, a lot of facts. We're probably going to have more than one expert, maybe even more than 2 experts. So best case international arbitration, I'd say 2 years, if everything goes right. And I remember this vividly. The color drained from his face. And he had this look of, it was of disbelief and then despondence. And he realized that arbitration wasn't going to fix his problem. It wasn't going to cover the hole in the balance sheet for the quarter, let alone the year. And in fact, in 2 years, you know, GE manager, he might not even do the same job. He could be moved on to someplace else. So clearly, arbitration was not the optimal procedure for meeting the business's expectations. But we told him where the negotiations stood, and the distance was not that great. And we thought that mediation might be the solution. He agreed to it. We proposed mediation, and he got on board with the process. The only hitch we had with the other side was agreeing on a mediator. Finally, we wound up choosing a retired judge who was listed on the panel of a very well-known institution. So it seemed like that dispute would also be progressing and getting underway towards a resolution. Now, I'd like to talk to you for a moment before I get further with these 3 cases about dispute resolution and the expectations of the business leaders that I have to work with. That look of despondency that I got from this general manager in that meeting had me thinking, I mean, in my world, 2 years for an international arbitration actually isn't that long. I mean, I was maybe being a little bit over-optimistic under pressure in a boardroom meeting. But the business leader, for him, that just seemed like it was ages. So I started to think, you know, I wonder, well, what is, you know, are there ideal notions of the speed of dispute resolution? And I decided to ask around 2 sets of stakeholders. I did some informal interviews asking litigators, again in different countries, and I asked business leaders, again in different countries. And well, I'll just show you what they said. So here are the questions that I proposed. Well, wait just 1 second. I asked them 2 sets of questions. You have to agree on what it is that you're talking about, right? All disputes are different. So I said, just think quickly. You've got a dispute of medium complexity and a value of $5 to $10 million. How long should an arbitration take? And I use arbitration because arbitration is elastic, right? It ought to be a process that can last however amount of time you want it to last. So tell me what you think in terms of dispute resolution. And then just to benchmark them and make sure that they understood I wasn't necessarily insisting on speed, I said, and what about if it were an expedited or fast-track arbitration? So let me give you these are the answers. We'll go here, and then if you can play the audio. Here are the litigation lawyers. And I think for many of the people in the room, I don't think any of this will sound very surprising.
Italian lawyer and Italian lawyer and English.
It's not going off.
Oh.
You have to play it.
I'm changing the slides.
Yeah.
Italian lawyer and
English.
litigation lawyers. Okay.
Okay, I'll say 9 months.
9 months.
9 months a year.
9 months a year. Okay. What if you had an expedited or fast track arbitration?
6 months.
6 months. You're a dispute resolution arbitration lawyer in Hungary, right?
That's correct. International arbitrations, if conducted very efficiently, could also be within 6 months after the terms of reference have been signed, but average is probably 2 years.
2 years. Okay. In your view, an expedited arbitration should take how long?
Fast track, maximum 3 months.
I'm from Siemens, I'm a senior counsel. My opinion is a normal medium arbitration should not take longer than 2 years.
And an expedited arbitration?
6 to 9 months.
And here in rapid succession are the lead litigation lawyers of the various divisions of my own company, General Electric. Medium complexity, normal arbitration, start to finish, how long?
1 year,
Expedited.
6 months.
Agreed. You have to say it.
1 year, 6 months.
1 year, 6 months.
18 months, 6 months.
I would say 18 months, 6 months.
1 year, 3 months.
1 year, 3 months.
1 year, 6 months.
18 months, 3 months.
18 months, 6 months.
1 year, 4 months.
1 year, 6 months.
9 months, 3 months. 18 months, 6 months. 1 year, 6 months.
Without discovery, 18 months, 3 months. There's 2 million pages in the case that the other side said, oh, it's I'm a little upset about it right now.
So this is a little discussion that we had there about it. So now we get the business
We
leaders.
negotiate contracts that have.
These are business leaders.
clauses, and then sometimes directly.
It's not time, it's not the day.
Long time.
Months.
It could take a couple of months.
And expedited arbitration.
A fast to me would be a week or 2. Any headaches, I would guess 2 to 3 months.
Without any headaches.
A month.
You negotiate contracts that have arbitration clauses in them.
Yes.
How long do you think an arbitration should last?
I think a month, a couple of months.
Okay. And if it was an expedited, a fast track arbitration?
3 to 4 weeks.
I would say it should take only 30 days,
What if you had an expedited arbitration?
15 days.
If these timeframes seem fast, here's Professor Mike Wheeler, Assistant Dean at the Harvard Business School.
I'm talking about my construction thing there, I think you want to do it in days. In days.
From the filing of a request for arbitration to an outcome.
If you're trying to put up a skyscraper on that, I don't think that people want to be sitting around with the whole project stopped because you don't know where you stand.
Italian lawyer.
Okay, so we need to,
English.
Litigation lawyers, okay.
Okay, I'll say 9 months.
9 months.
9 months, a year.
9 months a year. Okay, what if you had an expedite?
there we go. So there you go. That's the world that us in-house counsel have to face every day when you hear us venting about the time and the pressure of arbitration. And I thought a lot about the obvious disconnect between the lawyers here and the business people in these interviews. And if you look at the data that was gathered last week at London's conference on the future of global dispute resolution, which I encourage everybody in the field of dispute resolution to take a look at, you'll find many more disconnects between the various different stakeholders. I won't go through those examples because I'd like to get to a different point here, which is that I think it would be wrong to take too much of a lesson in this and say, well, arbitration is going to be done in days or weeks. Part of the responsibility of us in-house counsel, after all, is to explain to our clients that due process does take time. But I think that they understand this. And I've thought a lot about these interviews, which I did a few years ago. And it occurred to me that these business leaders, when they give these timing frames, their lips may say arbitration, but I don't think they're thinking about a lengthy legal process. What I think is in their mind is that they're going to go to someone who will hear each side's view and help them settle. In other words, when they're talking arbitration, but they're really thinking about mediation. So dispute resolution, I think, can be defined in really, the categories or the areas that affect dispute resolution, I think, really fall into 2 buckets or 2 categories. One is procedure, and the other is the people who are appointed to manage that procedure. And both of these categories are being addressed here in Singapore with the initiative here. And I'd like to talk just for a moment on procedure. As I think most of you, I hope, know or had a chance to look at, SIOC and SIMC are introducing a new and very innovative procedure that demands some attention, which I think it may address some of this disconnect between the parties and the lawyers. And that's the SIOC, SIMC, ARB-MED-ARB process, which needs a better name than the SIOC, SIMC, ARB. It's a mouthful. And it's actually much simpler than that mouthful implies. It turns tradition on its head, whereas traditionally parties like me would start a mediation. If that doesn't work, you start an arbitration. In this procedure, you start an arbitration, and then you try to mediate while the arbitration is underway. If you settle in a mediation, you can actually then convert that into a consent award in arbitration, and that is enforceable under the UN Convention for Recognition and Enforceability. If you don't settle, then it just continues on with arbitration. So I think that's something that we're seeing here today, which helps us align the dispute resolution process more along the lines of what the business community would like to see. In fact, I wish I could transport myself back in time to the boardroom meeting that I was in and say that, tell our general manager, yes, we actually have this process in place. It's agreed in the contract. It's an ARP-NET-ARP procedure. Hopefully we'll be able to work things through because it's contractual, but that was not the case. So let me go back to the stories that we were talking about here and recap a little bit about what happened with Anders and his case. Anders faced, as you guess, some cultural issues. And I've recently read some wonderful insights on human decision-making, an Asian perspective on mediation, edited by Joel Lee and Li Hui. Hope I pronounced that right. I met Joel last night and told him he made a mistake in the title by putting the word Asia in it, because the book raises issues on how culture impacts dispute resolution. And it's relevant to whether you're doing disputes anywhere on the planet. I mean, I think if somebody were in North America or in Europe, they would benefit immensely from reading this book because of what it makes you think about. In fact, in the case of Anders' dispute, it turned out that culture, or more accurate, I would say, assumptions about culture, was the main impediment to a solution. So despite the fact that the dispute was with the Norwegians, we were able to work cooperatively with them, and we got to a mediation in just about 2 weeks' time. And at that point, we're sitting in a room in Oslo in the mediator's office. And let me tell you a little bit about Swedes and Norwegians from a US lawyer's perspective. And that is, if I saw a group of Norwegians and Swedes on the street, I wouldn't be able to tell them apart. In fact, in our mediation, when I was in the room, everyone spoke English. But when they thought I was out of earshot, the Swedes would speak Swedish, the Norwegians would speak Norwegian, and they would all understand each other. And they were actually more informal with each other when they were each speaking their own language in the presence of each other. And there was a fairly good feeling that was developed there, but we didn't bridge the gap between us. We increased our offer from 100,000 to 150. They dropped their demand from 500,000 to 450. As the Swedes had to catch a flight home that evening, we ended the day with what experts would call a zone of negative agreement, where the parties just don't overlap, and it looked like we were heading towards no deal. I asked Anders for permission to take the other side out to dinner, make one last ditch attempt. He said, sure, you can try. In fact, he said, you can have all the way up to $300,000 in settlement authorization. You can just make this dispute go away, but it will never happen because of Norwegians. So I called the other side. They were very happy to meet me for dinner. And it was the owner of the other company was an engineer. We got to the restaurant. There was a bit of a wait. They asked us to go to the bar for a few minutes, and we're just literally just ordering beers, where this engineer, he was very nervous, and he blurts out, I feel very bad about this litigation. I'm an engineer. I've never been to court before, but I really felt I had no other option. He says, you're at 150,000, we're at 450. He says, what if we just split it in the middle at 300,000? And you return my prototype. I said, let me call Anders. So I called Anders. Anders was ecstatic. He was unbelievable. He said, this is unbelievable. This is incredible. I've never imagined this. I said, oh, but they want their prototype back. It was an awkward pause. And he said, I'll see if we can retrieve it from the rubbish bin. So we were able to do the deal. And I like referring to this story because of what happened some months after this. About a year later, I got a call from Anders. And he was stuck. Oh no, before I get to that, was something else. I asked the other side, I said, the 300,000, why didn't you we spent a whole day in mediation. I said, why didn't you make an offer to settle this case? We're there. And this Norwegian engineer looked at me and he said, I did want to make an offer. He said, but they're Swedes. So we sat there dancing around each other all day. But to get back, Anders calls me about a year later, and he says, I have this dispute. And he says, it's with a Swedish company in Stockholm, and the problem is they don't understand anything about mediation. They've got lawyers from Stockholm. Will you call them up and try to convince them to try to mediate with us? So, the mediation bug had bit Anders. Gavin, and I'll try to wrap up quickly here. The problem that we had with Gavin was a problem with lots of litigation, which was that it's too easy not to do anything once that you're already in court. And that was kind of what I did in this case. The case was in court, there was insurance involved. I didn't pick up the phone, I didn't take any action. Fortunately, Gavin did. Gavin took a bold move, and he wrote that letter to our CEO. As a result, we were able to agree to get to a mediation. And I looked around for a great mediator. I had a CEO mandate. I called lots of people. I even called John, brainstorming and proposed lots of names, and we settled finally on a mediator from London who specializes in personal injury mediation, Tony Allen from Cedar. We got together a few weeks later in Edinburgh, and Gavin, and we had the plenary session we spoke about earlier. We started this plenary session with Gavin saying he wanted to read a statement, and he got up and stood there with these pages, trembling in a prosthetic hand, and read how he was disappointed that no one in the company had reached out to him to try to resolve things before. He just wanted to move on with life, but the litigation was sucking all the energy out of him. He thanked us all for coming, and he said he hoped we would settle. He left us without a dry eye in the room, and I wish I could tell you that we met Gavin's expectations that day. But it was a hard case, and we didn't settle that day. The Caribbean refinery, by contrast, quickly got up and running. Our mediator, his retired judge, started off at a plenary session with a joint announcement to both sides that he had read GE's 10-page position paper, and he had read the refinery's 100-page brief. And it was clear to him that GE should collect nothing and instead pay the refinery millions of dollars. We were stunned. The other side was elated. But we were, and interestingly enough, we were no longer separated by this soft $3 million. We're now separated by a very hard, fixed-in-stone $25 million, and it became one of the most contentious arbitrations I've ever been involved in after this. That's how the mediation ended. On the plus side, the mediator was wrong. Our claims were not weak. We won most of them. Of course, we also spent hundreds of thousands of dollars, took some months of productive time away from our employees, and our victory killed any hope of recovering the commercial relationship with the customer. But that's the way things are in litigation. If you don't want to go to the funeral of your commercial relations, don't start the litigation. So that was our funeral. Very quickly with Gavin. 2 weeks after our mediation date failed to produce a settlement, the mediator, Tony Allen, called me on my cell phone. He thought a deal might still be possible. He was talking with both sides' lawyers, but he had a question. Was GE really serious about putting Gavin back to work? This was a no-brainer for us. In fact, it surprised me. I mean, I assumed Gavin just wanted to cash in and go on with life and do something else. He wanted his job back. We were paying him. Why wouldn't we want him back at work? So Tony asked for GE's commitment on this point. I gave it to him immediately. He hung up and he said he would be back to me. We then had another 2 weeks of phone tag, going back and forth with periodic updates from Tony. Finally, the phone call came through. We had a deal. We were able to settle. And this, by the way, is Gavin today. This is him after a race that he ran with some of his colleagues in Aberdeen this past year. I touched base with Gavin last week in preparing for today's conference. He says he tells friends all the time when he meets people who have legal problems that they should try mediation. He credits it with changing his life. I also spoke with Anders, who left GE a couple of years after our mediation. Today, he's the CEO of a Swedish company that, under his leadership, has grown from $200 million a year to $1.5 billion a year in revenues. And ironically, he also sits on the board of a small Norwegian company. But he says he hasn't had many conflicts, but he always makes the lawyers think about mediation first. And the really interesting thing to me here is that he developed this amazing relationship with the law firm that we were working with at the time. And he says he's using them in all of his M&A work, which upset me a little bit because we didn't even use them for the mediation. It was just they were there. They gave us some advice on Swedish and Norwegian law. But yet the impression left was so positive that he has built up this incredible relationship. I realized, I've got this laundry list of potentially former very happy clients who've experienced mediation in the past. So to conclude here, just right now, I'd like to wind up by pointing about the importance to a company like mine of the initiative that we're seeing here today, of getting us towards the results like the 2 settlements that we experienced. And if you have standards, if you have certification, if you've got transparency that gives you access to information about how mediators are, how they perform, what the parties think about them, you'll be able to avoid those sort of Caribbean refinery type situations where not only did we not get to a good result, we actually had something that turned out to be quite bad, which can do a lot to undermine confidence in the mediation process. 2 years ago, Michael Leeds, who's sitting here and is the founder of IMI, and really, I have to say, to me and I think to many people, one of the great leaders in international mediation, he gave a speech here on the future of ADR in 2020, where he made 10 predictions. I won't read them all to you. I'll tell you that there were 4 that I think have already come to fruition, and this is evidence of it today. He said the field of mediation by 2020 will become recognized as a true and independent profession. I submit to you that if you look at what is being reviewed here, this because there's no stronger evidence of it than this. He said there will be an even greater use of mediation by arbitration institutions. I'd say look to SEAC's presence and what they're doing here today. He said greater respect for mediation will result in interest being driven at the level of international organizations like the United Nations. Wow. Nobody thought that the UN, that UNCITRAL, would be considering a convention for the recognition and enforcement of international mediated settlement agreements. And yet, Michael accurately predicted that. He also said hybrids will flourish. Look at the process that is also being debuted of the ARB that we have. Okay. So, by the way, you can't give Michael credit too much for predicting the future because he's been so instrumental in shaping it himself. So, I'd like to quickly conclude by complimenting the organizers of this event, of these initiatives, and thanking you on behalf of my company for the sort of world that you're putting us into. And I hope that the model being created here is one that is going to be, it has to be followed by many others to come. So thank you.